Okay, hello and welcome to the first ever pre-recorded STA open call. As many of you know, we normally have these calls live and in a 4:30 to 5 p.m. time slot. However, given the holiday season and also the timeliness of this topic that we're going to be discussing tonight, we felt it was more appropriate to record the call and allow folks to kind of digest it and as they see fit. Listen, the topic that we're going to be discussing is the SEC's recent rule proposal calling for new disclosures and reporting requirements on securities lending loans. Please know that if you have any questions, you can email them to sta@securitytraders.org, and we will do our best to get a response to you. Also, please note that the call that you're watching right now was recorded on Wednesday, December 1st. So in case some new details come out between now and when we get this pushed out, please know that this is a little bit of a delay here. Listen, there's a lot of material that we're going to be covering tonight. So with that, we're just going to jump right into tonight's topic, okay? On November 18th, the SEC published and requested comment on proposed Rule 10C-1, which would for the first time require all lenders of securities to A, disclose material negotiated terms of securities lending transactions for public dissemination within a 15-minute reporting time limit, and B, provide security lending transaction data and aggregated information in respect of securities on loan and available to lend to a National Securities Association like Finra. And this requirement would be an end-of-day report. The proposed new reporting and disclosure requirements are extensive and will likely represent significant operational and compliance challenges for the broad range of market participants who engage and support the SEC lending business. So to help raise awareness and educate the broader industry on the significant development, STA is pleased to be providing today's call that will feature legal experts in this field. So presenting today, we have Larry Bergmann and Matt Comstock from the law firm Murphy McGonigle. Both Mr. Bergmann and Mr. Comstock's practices focus on complex regulatory matters with a focus on trading, short sale regulation, broker-dealer compliance, and enforcement matters. Both also were attorneys at the SEC and are currently located in Murphy McGonigle's Washington, D.C. office. Their complete bios are in the announcement, and we're very happy to have them with us here tonight. So gentlemen, thank you for joining us today. Before we get into a synopsis of the rule proposal, I thought maybe a good place to start here would just be if you could just maybe take a moment to describe the problem or problems that the SEC is looking to address with this new proposal.
Yeah, sure. So I think there are multiple possible reasons for why they're making the proposal now. The first major one being that in the Dodd-Frank Act, the SEC was mandated to take steps to increase information with respect to stock lending activity. Now, this rule proposal, this rulemaking was supposed to have been done in 2012. So you can see the SEC is a little behind, but I think they're trying to wrap up a number of their Dodd-Frank rulemaking requirements. So there's another underlying factor, I think, is SEC Rule 204 of Regulation Show, which, as you know, deals with closing fails to deliver. And many fails to deliver actually close out by borrowing rather than purchasing. So I think that may be another factor, and is mentioned by the Commission in its release. It should be noted, however, that 204 only applies to equity closeout situations, whereas this rule proposal is not limited to equity. It would also cover fixed income securities, which I think we'll talk about a little bit later. There is an overlapping Finra proposal, so Regulatory Notice 2119, which among other is pretty extensive, but among other things, it talks about exploring a possible reporting framework around stock lending. So this proposal may supersede that. Not clear because it's not mentioned in the SEC's release. There is also a NSCC proposal, which is mentioned in the release, which is a proposal to centrally clear securities financing activities, which would include stock loans. That's still pending at the commission. So the stated objectives in the release are to provide investors and other market participants with access to pricing and other material information regarding securities lending transactions in a timely manner, and to provide regulators with information for their market oversight functions. As Jim mentioned, the release is 187 pages long. Comments are due 30 days after Federal Register publication, which as of the moment, I don't believe has occurred. There already is a comment letter in by multiple organizations, including STA, to request a longer comment period because this proposal is pretty significant in complexity. The SEC published a fact sheet, which is pretty general, pretty informative, giving the general overview of the rule. So you may want to take a look at that. And in our discussion today, I'd point out that the rule requires reporting to a registered National Securities Association. However, there is only one. So all these reports would be made to Finra. And I think that's where sort of the genesis of the proposal.
So I think the next three questions that we'd like to kind of cover here are really a synopsis on what's in the rule itself. And obviously, like you touched upon, it's 187 pages. So maybe if we could just kind of outline the next three questions around, you know, what securities are covered under the proposal. You did touch on fixed income. Second, what information is required to be reported and when? And then third, who has the reporting responsibility? So why don't we just start with securities? Maybe you want to start with the first one. If you want to combine the first and second as far as what securities are covered under the proposal, and then what information is required and when, maybe that's a good place for you to, you know, maybe split it up or, you know, however you want to take it.
Yeah, I kind of think of this as sort of dealing with who, what, when, where, and why. So the initial focus is securities lenders. So that's anybody who loans a security on behalf of themselves or somebody else. So a lender technically would cover the beneficial owner of the security and any intermediary that lends the securities on behalf of that beneficial owner. And the intermediaries are called lending agents in the rule. And it's interesting that there is no definition of lending agent in the rule, but where it describes lending agents, it refers to banks, clearing agencies, brokers, and dealers. And it looks like those are the only lending agents the rule is focusing on, because they're the ones who would be filing data on behalf of the beneficial owners. There can be other lending agents, but these are the ones that are the main focus of the rule. And then the other major category are reporting agents. So a broker-dealer can enter into a written agreement with a person that's required to report under the rule, a lender, and report the information on its behalf to Finra within the required timeframes that Jim mentioned earlier. So reporting agents must be broker-dealers. They have to have written policies and procedures to provide the information required by the rule. They have to enter into a written agreement with the lender to report the data. They have to enter into a written agreement with Finra that permits the agent to provide the information on behalf of another person, and also provide Finra with a list of the persons and the lending agents, including the lending agents on whose behalf the reporting agent is providing the information. The reporting agent would have to preserve in its records all of the data and the written agreements for 3 years, sort of a typical record-keeping obligation for a broker-dealer, and which would also include the time of receipt of the information from the person on whose behalf they were reporting. And the idea here is, of course, that broker-dealers are subject to SEC and FINRA oversight, so they can have easy access to the records. So what needs to be reported? Specific details about every lending transaction have to be reported to FINRA. The data, some of the data will be made public by FINRA and some will not. So there are 12 items of information that have to be reported to FINRA within 15 minutes after each loan is effected, which basically means when the parties agreed to the loan transaction. And FINRA will make them public as soon as practicable, basically contemporaneously with the receipt of the information by FINRA. The information is in this category regards the issuer, the identity of the issuer, the security, the details of the loan, including the date, time, amount, type of collateral, rebate rate, or other fees, termination date, and whether the borrower is a broker-dealer, a customer of a broker-dealer, a clearing agency, bank, custodian, or other person. FINRA will assign a unique identifier to each one of these reports, each loan. And loan modifications that affect any of the data, those data elements also must be reported to FINRA with the date and time of modification, description of the modification, and the unique identifier FINRA applies to the loan. This information would also be made public. Now, there are some confidential data elements. For example, the legal name of each party to the transaction, CRD number, IARD number, MPID, LEI, where applicable, and whether the party is a lender, the borrower, or an intermediary. If the lender is a BD and the borrower is a customer, whether the security is loaned from the BD's inventory or not, and whether the loan is being used to close out or fail to deliver pursuant to Rule 204 of Reg Show, or to close out or fail to deliver outside of Reg Show. As I mentioned, Reg Show only applies to equity, so the 204 reference is only to equity. Now there's other data that would also be required to be reported, which would be, and this is in paragraph E of the rule, would include the issuer and security information, the total amount of security that's available to lend. If the lending agent is a broker-dealer, the amount available owned by the broker, by its customers who have agreed to participate in a fully paid lending program, or in customer margin accounts. If the agent isn't a broker-dealer, the total amount of each security available to the agent, including the securities owned by the agent, the total amount of security that had been contractually booked and settled by the lending agent, i.e. what is on loan from the agent. If the lending agent is not used, similar information has to be reported directly to FINRA or a reporting agent that would report the information to FINRA. This data would be aggregated by FINRA and made public without any identifying information no later than the next business day after it's reported. When does this have to be done? As you know, we've mentioned already, every loan and loan modification has to be reported to FINRA within 15 minutes of making the loan. And data on the securities available for loan and securities available for loan and on loan must be reported by the end of each business day. That's the aggregated data. So where these things have to be reported, as we mentioned, it's to FINRA. And the information that FINRA must make public will be on a publicly available website or a similar electronic means without charge and without use restrictions. FINRA also has to have policies and procedures to protect the confidentiality of the confidential information that it receives. And FINRA has to keep all of this for 5 years and maintain public availability of the public data also for 5 years.
So I'll tell you, before you go on, I just want to go back. So there's a couple of questions I have with some of the comments that you made. Going back to lending agents. Are all lending agents broker dealers, or are there some lending agents that are just acting more like in a vendor type? The I guess in the equity world, we just kind of consider them vendors. Are there any lending agents who are not broker dealers? And is that why the reporting broker dealer part of the rule is being put in place, because these lending agents are not BDs, therefore Finra has no authority over them, or are they all broker dealers?
Yeah, Matt should weigh in on this too. As I said, I think it's a little ambiguous to me within the rule as to, certainly are lending agents that are not broker dealers,
Right.
and not banks, et cetera. But the question is, who needs to report the information if you're not a broker dealer, bank, or clearing agency? And because those entities can report, must report if they're intermediating a loan. But the other ones, the information has to be reported. But the question is, who's going to report if you're not a broker, bank, clearing agency? And I think there, the lender has to report directly to Finra or hire a reporting agent, which would be a broker dealer.
Right. Okay. Yeah, that's how I kind of read it too. So I mean, that's kind of a new, that those are going to be new arrangements, new contracts, and that they take a little bit. I'd like to see some of the details around that. You also talked about the information that's being reported in aggregate at the end of the day, in particular around the amount of loan that's available, how much stock loan is available, that gets reported at the end of the day. I mean, in your experiences, and obviously if you don't have any experience here, please don't feel that you need to answer this, but if that information is getting reported at the end of the day, and we do get like a volatile day like we had today in the markets, I mean, do you think that number changes the next day? Can that number change drastically the next day, where making the information somewhat not useful? Are there wild swings in that number?
Well, I think there certainly could be if, for example, there's a heavy short selling on a particular day, and the short sellers need to borrow the stock.
Right.
There could be a spike in loans, and that number could change, I think, pretty significantly.
Yeah. Okay. And as far as the information also that has to get reported around in 15 minutes with the changes in the in any terms of these loans. I mean, is that something also that does that happen often to in your experiences, or in what you've seen? Like, so for example, I'm just going to make up some numbers here. If I do 100 transactions a day, if I'm where I'm lending out securities, I'm holding them on my books for a certain period of time, whether it's 30 days, 50 days, or 60 days. Over a period of time, obviously, if I'm doing 100 a day, over a period of time, I'm getting a rather large amount of positions on my books. Do the terms of those agreements change? Is there a lot of changes going on there where there's going to be a lot of reporting that has to get done that's not that initial transaction in that 15-minute window? Or do those terms somewhat stay the same through the beginning and end when they get closed out?
Yeah, modifications need to be reported only if they affect one of the 12 items, although obviously the 12 items are pretty comprehensive. Yeah, I mean, if the loan is extended for a period of time, or terminated, or the rebate rate changes, something like that, yeah, all those are going to have to be reported, and could put some pressure on the systems of the broker dealers.
Okay. All right. So why don't we try to move on to the question like number 4 here, which is of the information that is required to be collected and obviously passed on within a 15-minute window. Is there any information in there that's going to be required in the rule that's not being collected today, or is all the information that the SEC's requesting to be reported within 15 minutes? Is it kind of standard practice where that stuff is being collected and categorized already today, And this is more of a, how do we get it from, get it from our database over to Finra? So if any color around that would be helpful.
Yeah, I mean, it's a fair question. I think that there is some data certainly that is not collected today simply because of the structure of the rule, right? So now, if you have a reporting agent, for example, the reporting agent has to note the time that it receives the information from, from the lending agent, and then has to note the time that it transmits that information to Finra, right? So that's new information that's not available now. There's also a requirement to keep a record of the time that the loans were entered into. Now, I think as a practical matter, I'm sure just for basic bookkeeping purposes, the entities that are entering into securities loans are going to note when they entered into them. But I also think there's a difference between, hey, party A and party B entered into a loan on December 1, and these are sort of the terms, as opposed to, for purposes of meeting the 15-minute requirement, you have to note that, hey, party A and party B entered into this loan agreement as of 1/19/37 on December 1, and then that was transmitted to the reporting agent who received it at whatever time, et cetera, and then FINRA can trace, or the SEC could trace if they wanted to, the exact amount of time from the point at which the loan was affected until it ended up at FINRA.
I would say that, Jim, also that while all of this, or a large portion of this information may also already be collected and available to broker dealers, this is requiring standardized reporting. So they're going to have to adjust their systems to report it in the way the rule would require.
Right, and there are a number of entities involved, but the ultimate entity that's receiving the information is FINRA. So you can imagine that FINRA is going to drive the formatting process or formatting approach.
And what if no one wants to be a reporting BD? So I'm just thinking from the perspective of I'm a small to mid-size asset manager. I'm involved. I rely on my lending agent to help me lend out 10% of my portfolio here. They're not a broker dealer. They're going to have to go out and find a broker dealer to be their reporting broker dealer. I mean, you can't regulate someone to become a reporting broker dealer, right? So that's really no question. There's no question now. I just thought I'd throw it out there. I mean, it says that could be an unforeseen consequence here. I mean, maybe there's no, if I'm a larger firm and I'm reporting my own activity directly to FINRA, or if I'm a lending agent and I am a broker dealer and I have my list of clients here, I mean, why am I going to take on a smaller lending agent who's not a BD and then take on the liability, the reporting that comes along with that?
Well, it's a good question. One of the things that is not mentioned in the release regarding reporting broker dealers is whether or not this would be a revenue source for them.
Right.
So maybe a small broker dealer or somebody niche player wants to get into this business and see a revenue opportunity, but obviously that would be up to each broker dealer. There's no requirement to become one, but you could become one.
Yeah, and look, to your point about sort of smaller players in the securities lending industry, and this is the debate we were having earlier, which is it's not abundantly clear. The assumption that I have based on the rule is that if some sort of lender wants to itself report, and it's not a broker dealer, it could report to FINRA, but you can also imagine that it's not going to be well equipped to do that, and there are going to be multiple entities that are in that position. So I would think that there's a good chance that some brokers are going to want to step up and, to Larry's point, view this as a revenue source and provide that connectivity. But you're right, it's certainly not guaranteed. And as Larry pointed out, there's nothing in the proposing release that discusses sort of economics for, a reporting broker. Now, I wouldn't expect them to go into great detail, but I would expect them to acknowledge, hey, look, we anticipate that reporting broker dealers or reporting agents will, charge fees for their services or something along those lines.
Okay, I'll take a look. It could, I know there are 94 questions attached to it, so maybe that is one of the, I wouldn't be surprised if that's one of the questions that they do ask. In
Yeah.
this. So, all right, so listen, we have around like a little over 5 minutes here. I would like to kind of just talk to, like, what are the next steps here? I mean, for firms, what would you, be suggesting? I don't want to say, I don't want to use a strong word like recommending, but, but what would you be suggesting firms what course of action they should be taking at this stage?
Well, I'll take the first shot at it, Jim. So when I step back and look at this 187 pages or whatever, I ask myself, what is the problem here? What is it? I always sort of ask myself, is this a solution in search of a problem? Or are they taking like a sledgehammer to kill a gnat in this regard? Because this is going to be very expensive I think for a lot of firms. It is going to consume resources. It's going to also require a lot of Finra rulemaking, as Matt was alluding to. Fees, for example, Finra is going to have to set up this public website and everything. And the release says that Finra will have to bear the initial cost, but then could have fee filings to collect and reimburse himself and pay for the ongoing costs. So there are going to be costs involved. So one of the areas I specifically look at is fixed income. So as far as I know, there haven't been too much information. There isn't much information out there about problems in the fixed income lending market. The only area where I know it has come up is in the government securities market. Occasionally, you get some real short squeezes and problems there, and the market kind of freezes up. But those are pretty rare too. And ironically, the release asks the question, one of the multiple questions, is should this rule exclude government securities, even if fixed income securities are covered? So I mentioned that Rule 204 has been the commission's focus in terms of fails to deliver and borrowing, and that only applies to equity. So this would be a pretty significant extension of monitoring and reporting on stock lending. So what should STA members be thinking of? Thinking of commenting on the overall impact on individual broker dealers, especially smaller broker dealers, as we were pointing out. They're going to have to collect a very granular level of data, standardize it, send it off within very tight timeframes. When you're talking about 15 minutes to Finra, going to have connections to Finra. Shouldn't be a problem for broker dealers, but for other lenders or intermediaries, that could be another issue. You have to have policies and procedures, and of course, once you have policies and procedures, you have to have WSPs to see that they're being followed. And if they're not being followed, of course, that you could run into problems with regulators. So I think it's definitely something worth firms individually and collectively looking for areas where this would perhaps be a proposal that goes too far.
Yeah, I think next steps for firms, echoing what Larry said, are to figure out what their comments are and make sure they get them to the SEC, hopefully within 90 days as opposed to 30. But yeah, that's crucial. And to the extent that there are parts of industry groups, I think industry action I think always carries a lot of weight with the SEC staff, as opposed to, not that they ignore individual comments, but group comments, I think, carry a lot of weight.
Yeah.
I mean, listen, I think where we're struggling with this internally is like there are differences. There's a difference between a rule providing a benefit and a rule which provides a protection. And I think we can kind of look at this and feel around and say, yeah, there are some efficiencies that need to be brought to this marketplace. There's something within this rule proposal that can make this marketplace a little less opaque, inject some efficiencies within it. But if there isn't a major investor protection issue here, why the 30 days? Why all the cost? Why the hammer to do it? So I think that's kind of where we're we're just gonna have to spend some time just trying to reflect on it and talk around it. So I just want to thank you both for. I'm gonna kind of wrap it up there and just thank you both for taking the time out. To spend time with STA today. And we'll certainly keep you up on our letter. Hopefully the industry can get a little bit more time on the clock for us to read this and comment on it. And I just thank you again for taking the time to speak to our members.
Our
Thanks,
pleasure.
Jim.
Thanks for inviting us.
All right, thank you.